today, 20th, tomorrow, 21st, and 22nd November 2023. Before the matter commenced, an application was made by the defense, and for some length, the application revolved on the propriety of the case hearing and whether it meets the constitutional thresholds. Mr. Ondieki, Mr. Njiru, Mr. Aaron Bubi, and Mr. Biko jointly appeared for the accused persons. Mr. Ondieki went first. These were his submissions. He submitted that either on Thursday or Friday of last week, he was served with a bundle of witness statements. On his cursory look at the statements, he established that his plan, the 12 accused persons, were listed as witnesses and their witness statements were served on him. This to him posed a constitutional challenge as it was a direct confrontation to Article 52A of the Constitution on the right to be presumed innocent until contrary is proved. And secondly, Article 52J, the accused right to remain silent and not to testify during proceedings. And further, Article 52L, the right not to give self-incriminating evidence. He submitted that the prosecution act of serving him with the accused person's statement was through the back door seeking to compel the accused to give self-incriminating evidence under the circumstances. Mr. Njiru, whom I must commend for his brief and precise submissions, fully associated himself with the submissions by Mr. Ondieki. He expounded on the violation as espoused by Counsel Ondieki and was in agreement with Mr. Ondieki that if the matter proceeds as it is, then it would create a constitutional crisis as to the accused right not to incriminate themselves and their right to remain silent were exposed to violation. He passionately submitted that the prosecution's action eliminates the Prosecution Act of impunity and clear abuse of the office by the prosecution. He posed as to what remedies would be available to the said violation were the case be allowed to proceed as it is. Mr. Ndubi, on his part, submitted that the issues raised by his colleagues were important constitutional questions, which, according to him, could only be answered by the High Court. He submitted that the prosecution's action exhibit impunity and an attempt to violate the Constitution, which he proudly participated in drafting. He submitted that an accused cannot be tried on this at the same time be made to testify against himself at the same time. Mr. Ndubi similarly submitted that there is a pending case in Makadara law courts where the accused persons are charged on similar facts. He submitted that this court only has two options to operate on. First, refer the matter to the High Court to give answers to the constitutional questions raised. And secondly, allow the defense time to file an application in the High Court to have the two matters consolidated. Mr. Ndubi similarly raised questions as to the charge sheet. The question likely revolved on the form of the charge sheet, which he pointed out that the signature appearing on the face does not resemble a signature, and that the name and rank of the prosecutor is not indicated. He termed the charge sheet as defective. He too submitted that the particulars of the charge sheet as set out contradict themselves making it impossible for the accused to understand the same. Mr. Biko, with much inclination to the submissions by Mr. Ongiri and Mr. Njiru, submitted in furtherance that the prosecutor, despite gangs being involved in the charge, have not presented ballistic reports to them. He submitted that no government analyst report has been served on them. He took issue with the late service of the witness statement by the prosecution, stating that it made it difficult for the defense to prepare for the hearing. The learned prosecutor had this to say in response. First, he stated that he served the witness statement and no documentary exhibits. They intend to rely upon Mr. Ongiri via WhatsApp on the 18th of July 2023. And Mr. Ongiri acknowledged receipt of the same upon making a follow-up call. He was categorical that the prosecution were not calling any of the accused as state witnesses. On the issue of the alleged pending case in Nairobi, he submitted that no material had been presented in support of that submission. He maintained further that the charge sheet as it is proper. He asked that the application by the defense be rejected and the matter be allowed to proceed. This is my considered view. At the beginning of the application, there was an obvious constitutional question that would have called for an examination. This was particularly the question that bordered violation of the accused's rights under Article 52A, fifth right to be presumed innocent until contrary is proved. Secondly, Article 52J, I, the right to remain silent and not to testify during the proceedings. And further, Article 52L, rights not to give self-incriminating evidence. This fear was though diffused by the prosecution's undertaking that they were not calling any of the accused person as a state witness. I now move to the second limb of the application respecting late supply of statement and other documentary exhibits to be relied on by the prosecution. This is a right under Article 52J that provides that a person charged has a right to be informed in advance of the evidence the prosecution intends to rely on and to have reasonable access to that evidence. The foundation of this application is the defense assertion that he was supplied with the witness statement less than 36 hours to the trial. The learned prosecutor submitted that he served the documents and the statements on the 18th of July 2023, and he resent the documents sometimes last week. This fact is not refuted by Mr. Ongiri, who acknowledged to have received the documents, but printed them out last week. Electronic service is permitted under the law. The prosecution's service of document to the learned counsel cannot be faulted. I will respect all that the defense were duly served with the statement well in advance, and the period of service permitted adequate preparation for the defense. An issue was raised by learned counsel Luby that there is a pending matter in Nairobi touching on similar facts. Regrettably, nothing has been placed before me to support that. not even the particulars of the same case. At the moment, I refuse to make any further comment on that, but I disallow any application involving on that. Mr. Nubi asked the court to adjourn the matter to enable the defense file an application to consolidate the two matters. This application would amount to calling upon the court to act in anticipation, as stated in the form, without substantive evidence that the existing case, if any, relate to similar fact, as the instant case leaves the application there and unsupported. As I conclude, an issue was raised by Mr. Njenga to the effect that the entirety of the process adopted by the DPP in the case borders impunity and abuse of power by the said office. Hence, the entirety of trial process is, in Mr. Njenga's words, contaminated. Mr. Njenga's concern is what remedies would be available to his client in the premise. Whereas this did not receive a direct response from the prosecution, the issue is worth my comment. Mr. Njenga has been consistent with the motive of the institution of the case hearing. He has raised this issue on all the appearances he has made in this case. It is not an issue that can be wished away. The motive is a question, though that can be best. The motive is a question, though that can be best articulated at the trial and may form a question for determination at the end. It is not an issue that can be dealt with at the pre-evidence stage. It is a factual question I cannot make a determination on at this stage. In the end, I do not, with tremendous respect, find a cause to adjourn this matter. As much as it is the defense calling for adjournment, it is similarly an accused right under Article 52E to have the trial begin and conclude without unreasonable delay. This matter was fixed for hearing 5 months ago, as I had stated, and fixed for 3 consecutive days with the intention to guarantee the accused persons the latter right. Consequent thereto, I direct that the trial hearing proceeds as scheduled. Those are the orders of the court.